folks. I'm Colleen Barry, back with another episode of the Privacy Huddle. If we don't know each other, my name is Colleen. I lead marketing at Ketch, a data privacy software company. And the Privacy Huddle is our weekly series where we talk about privacy industry trends, topics, headlines of all sorts. I am so thrilled to be here today with two guests on the huddle, my friends Max and Ezra, and we're excited to chop it up about some new trends and old trends and what privacy leaders are currently grappling with. So let's start with some intros. Ezra, what a pleasure to have you here on our little show. Please tell the audience who you are.
Thank you so much. It's great to be here. My name is Ezra Sternstein, and I lead the privacy, cybersecurity, and consumer protection legal functions at AMC Global Media. We are a company that makes content. We know Breaking Bad, Walking Dead Universe, Mad Men, Better Call Saul, and so on. The list goes on.
I love it. Big job at a great company.
I just want to add one thing, which is that I am speaking on my own behalf and not on behalf of my employer, or certainly on behalf of the Attorney General of the state of New York or any other state.
Max, some of our viewers know who you are. You're a familiar face, hopefully a comforting face. Tell us who you are.
Hi guys, I'm Max Anderson. I'm one of the co-founders and head of product. It's good to be here.
So Ezra, back to you. You're a new guest on the show, and I would love to hear just a little bit about your background. Privacy is a discipline that many folks stumble into, not always a straight and clear path that's winding. What first got you interested in privacy, and how did you end up here?
Well, I definitely did not take a direct path to privacy. I started off my career after law school at a big law firm in New York City, and I enjoyed law school, so I went into litigation, which to me felt like the natural progression afterwards. And I was doing litigation at a big firm for a number of years, and in my 6th year or so, my mentor pulled me aside and said, if you want to have a strong future here, you should start thinking about a specialty. Up until that point, I'd been a generalist, and that's actually what drew me to the firm, because I didn't know what I wanted to do. I had no idea, except for to pay off my student loans. That I knew I needed to do, and so I started looking around, maybe what I should have done after law school. So what area was really interesting to me? This is around the time that the GDPR was being considered and passed. It hadn't been brought into force yet, but other things were starting to burble up, and all of a sudden there was Cambridge Analytica, and then California started to get into the regulatory game, and it seemed to me that there was this opportunity for me to get into privacy. I felt like I had a stake in it as a person with data that I didn't really have in any of the other areas of law that I had. And so I started thinking, okay, how do I get into this? At this point, I'm an 8th year big law litigator generalist. What do I do? And my firm did not have this practice. But I was lucky enough to get a job at the New York Attorney General's office in the Bureau of Internet and Technology, which is called BIT. And BIT is the smallest group in the New York Attorney General's office. There were 7 or 8 attorneys when I joined, and it's focused, and still is focused, on enforcing New York state and federal law concerning privacy, cybersecurity, consumer protection. Obviously no comprehensive law in New York, but through general consumer protection statutes, stuff like the FTC. I was there as a regulator, as an enforcer, for 4.5 really wonderful years. And then when I started looking for, okay, what's my next, now I have this privacy background, or at least background in the substantive area, how do I transition? What's my next job? And I was really fortunate to get a job at AMC doing what I'm doing now.
I love it. What a cool background, from outside counsel to regulator to inside on the brand side. When I think about privacy trends right now, you can't get away from all the enforcement headlines, right? And when you think from the regulatory side with that old hat on, what do you think a lot of brand leaders are overlooking or missing today?
That's a good question. I don't know if misunderstanding is the right word or if misalignment is the right word, but one thing that leaped out at me in some of the recent settlements in media, particularly Disney and Sling, was this. It was very evident that these companies had posited as a defense to the regulators, we don't have the right technology. We have problems with our vendors. We have technical limitations. We can't propagate this opt-out in the way that you want us to. We just don't have the ability to. And the reason that we know that this was a defense in those cases is because it's in the settlement agreements. The Attorney General says The company says that it could not propagate its opt-out because of vendor limitations, but its ad sales department didn't have that problem. Right? It's almost a laugh line in these. And so I think that one of the things that privacy leaders may have thought, but certainly don't or shouldn't be thinking anymore, is if I come close, if I don't have the right tools, but I have a story to tell, and I'm not strictly compliant, but I have some story, and I can blame someone else, then maybe that's a story that I can tell the regulators. And I think what is very clear now is the regulators don't want to hear that. They want you to comply, and this was certainly the case when I was in the Attorney General's office. The view is this is the law, and don't come and tell us that you can't comply with the law. You have to find a way.
Absolutely.
Given your background at the AG's office, what do you think the likelihood is of, at some point, enforcement being focused on vendors, whether it be insufficient capabilities or claims that are being made about the capabilities that may not be true in real life?
Those are two different things, and not legal advice. This may be near and dear to your heart as a vendor in this space, but for the capabilities that you're offering to your customers, and any vendor is offering to their customers in this space, I think it's very unlikely that any regulatory authority would be probing the vendor. I think it's the business's responsibility, first and foremost, to do due diligence on the vendor, make sure that they can operate in the way that the business wants or needs them to operate, to handle their data. And in most cases, the vendor is contractually required to honor the business's directions, unless the directions themselves are unlawful. And the business is in the best position. They know their own data, they know their business, and they are or should be advised by good lawyers who know how those laws apply to the business and to that data. And so I think for the most part, I think it's very unlikely that anything like that would happen. Of course, if you're not truthful about what the capabilities are, that's a different claim, and that to me is a consumer protection issue. We've seen in New York some cases actually where businesses, not just consumers who are individuals, but businesses themselves have been the consumer for purposes of enforcing those laws. We've seen that in the AI space, where AI companies, some startups, are not necessarily truthful or are over-exaggerating their abilities and their claims. And
software?
Who would have thought? So you do have to be truthful in what you can do, but as long as you are truthful, I don't think that Attorney General should be too much of a problem given the business's processing of their data.
It's interesting. We've been in software for a while, and formerly more marketing and ad tech. And so the nature of the problems that you're solving and the unfortunate reality of the software game is that there's a lot of the ratio of claim to pay down is a little bit out of whack, unfortunately, in most software categories. But the stakes don't seem as high if you're slinging ad tech software, whereas the nature of a privacy software company and the nature of the kinds of things that happen when things go incorrectly, there's a couple of vendors that are most commonly involved as the provider in a lot of these suits. And so it just strikes me as more likely that, given the nature of what's happening in the category, that there would be some spillover into a unfair, deceptive business practice type investigation, just because, hey, I'm enforcing all these companies and there's a common element in all of these enforcements. I wonder if I should go tell Bill over there about this thing. I'm just wondering, does it work like that? Is that completely far-fetched?
The regulators are going to be more focused on the consumer as an individual, right? That's their mission, is to protect the residents of their jurisdiction. And so to the extent that a vendor has a business in between it, and the business is the one interacting with the consumer, I do think it's unlikely. Not impossible, obviously, but that being said, anyone can read these settlements. Anyone can see what the California regulators thought of Disney's argument about its software suite, and smart and knowledgeable people can read that and figure out that maybe there's some space here to iterate or to improve and to get to and help businesses get to a place where they can satisfy the regulatory enforcement. Of course, if you're telling the business that you can do it and then the business is not doing it because the software can't do it, maybe there's indemnity issues in the contract. That might be some way that a vendor could wind up with
fall victim to that unfortunate claim to pay down disparity.
Yeah, exactly. All of a sudden, no. The business says, "Well, I thought this was happening because that's what here's all the communications where the vendor assured me that this was happening that way." they're going to indemnify me for these claims that I'm receiving because we're not doing it. So that's also, I guess, a potential way, an avenue that I can have. I don't mean to scare you.
I feel great.
I mean, look, back to your point, Ezra, I can't see it happening. And we hear on so many regulator panels at these conferences, they consistently reinforce, regardless of what your vendor is doing, you are on the hook.
Yes,
brand,
I think that's
because they care about the consumer and they step into the consumer's shoes. The closest I've heard to them intimating any kind of looking into the vendors is we have calls for comments and you're welcome to submit those thoughts there.
A few murmurs at CLA this year, and I'm
Exactly.
just been fixated on this idea. I'm just wondering, is that really possible? I mean, it would be an interesting outcome, but of course I would ask someone who's got experience to opine more effectively than I can.
We'll see. The industry is really going through this evolution of going from privacy as cookies and cookie banner and web form to a more data and complex problem. I think one of the common themes and threads we see there is, of course, identity and the concept of identity management and privacy. Let's talk about identity for a moment as it relates to privacy. Max, can you break down what we're seeing in the settlements as far as the problem that the regulators are suggesting to the brands to fix?
Yeah, I think the first one is relatively obvious and easy. It's the idea that you make a choice on one of the devices that you use, and it should be reflected, respected, et cetera, on the other devices that you use to engage with that brand. There's, of course, a lot of nuance around whether or not the individual is logged in, and we can dig into that if we choose, but that's requirement one. And I think the other one that may not always be pegged as an identity requirement is the opt-out of sale invocation coming from a form that has no impact on the trackers, the cookies, whatever you want to call them, beacons, network requests, et cetera, for data collection. And the lack of connectivity between those two things, of course, buttresses this frictionless requirement, but it's in and of itself fundamentally an identity issue for a lot of boring reasons that we can unpack, but that's the number one misunderstood thing in the identity arena, not just cross-device, but there's a frictionless expectation that is hindered by a lack of identity behind the scenes.
Ezra, how are you thinking about identity as a kind of tenant or responsibility within your privacy program?
I sort of see our role in privacy as being a conductor of the orchestra, right? We're not the soloist. Identity is going to be defined by the product team and the business team because they need a product that works and they need a product that they can monetize, and they're going to have some identity layer that is going to be defined, at least at our organization. Yeah. And it's not my decision to make. At least I don't feel that way. I don't feel like I should be telling the business, you need to have this identity or this identity, or you need to link people in this way. The business is going to tell me what they want to do, and then my job is to work with them and to counsel them on, okay, well, if you want to do it this way, then these are the issues that are likely to arise from that. And if you want to do it this way, then these are the issues that get solved, and these are the other issues that arise. And we have to work through that. But there's a lot of different identities that you choose. My email address might be one, or there might be some string of numbers that uses as an identifier. And that's going to depend on, I think, what the product team is telling you is going to be the one that doesn't make the app crash. Because you're not going to monetize anything that doesn't work. So that's how I see our role.
Yeah, and so as you talk about that, working with product team, working with marketers, digital, whoever, the cross-functional collaboration is equally important, right? To make sure that they have the trust in you to share with you what they're up to. How do you make sure that happens on a regular basis?
We like to think of ourselves as nimble. There are media companies that are orders of magnitude larger than we are. We're still a small-ish organization in this industry. And at least for me, it's easy enough to set up a meeting or to get a call with the right people. I've been there now for 3 years. I know who the right people are. I know who report to the right people. And that's really how I do it anyway. Just get the right people on the call. We have processes also, right? We have intake forms. Okay, you want to do something new or do something different, or you have to fill out this form that explains to me what the data is and what you're going to do with it and how you're going to use it and who you're going to send it to. And then we can have that conversation about what needs to get done, what issues arise from that. I'm very fortunate, I think, in my position where I don't have a whole lot of layers to go through in order to reach the decision makers.
I'd love to touch on one more topic with you, Ezra, which is these recent amendments to the CCPA, right? We saw the new amendments come out on risk assessments, ADMT, and then cybersecurity. That last in particular is new territory for many privacy pros, but yourself maybe not, since that is under your purview at AMC Global Media. So I'd love to get your perspective on how you're looking at handling these new amendments and maybe advice to privacy pros that haven't typically had cybersecurity under their purview, right? Something new to deal with.
Yeah, definitely. So as I mentioned at the outset, I do also lead the cybersecurity legal function. And during my time at the Attorney General's office, one of the responsibilities that our bureau had was to investigate. We would receive all data breach notifications. That our department was the one that intook those. As you may know, there's a lot of, all 50 states have data breach notification laws. Usually you have to report to the Attorney General of that state. And so that was our bureau, and we were then charged with investigating ones. So I do have a number of data breach investigations, cybersecurity investigations under my belt. So that is very helpful background. And I understand not all privacy practitioners who practice sort of pure privacy may have. That being said, there's always, I think, been a kind of a Venn diagram between privacy and cybersecurity. There's some overlap. Those circles are squashing together now with these amendments. It's really long. It's very exhaustive. There's 5 or 6 pages of very specific, very prescriptive requirements that the business needs to analyze. And I think the question that a lot of companies may face is, well, who is responsible for this? It's a privacy law, but it's a cybersecurity aspect, and there's a whole audit component. So as a public company, I think most public companies have some sort of audit function already built in that you may be able to leverage. There's requirements in the statute about who the auditor needs to be, how independent they need to be, and so obviously any company's mileage may vary with their own internal audit. But some companies may not have any audit function. Private companies, small companies may rely on an external auditor, and it's going to be very costly to do this. This may not be something that they've done. The challenge for the privacy practitioner, particularly if they're the one charged with this because it's a CCPA, to become more educated in cybersecurity generally, but also how your company handles cybersecurity and handles data protection with respect to personal data. And I think the 2 pieces of advice that I have at this moment, it's still early. The first audit isn't due for another little less than 2 years now, is number 1, you need to have a data map. You've got to know where your data is and what systems store what data, because not all of your assets and databases may even be in scope for this. If they're not handling Californians' personal data, they may be mission critical to the business in some way, but they're not part of this. So you need to have a data map and know what you actually need to look at. And number 2 is to become really good friends with your CISO or whoever else holds that security operations function at your business. Who's in charge of cybersecurity? Who knows what the company is doing? Who's engaging those vendors? Who's doing the pen tests? That person is going to become your best friend in 2027 if they're not already. So start that. Buy them coffee. Do something to get them on your side.
I'm curious on that topic. Certainly, I subscribe to the idea that privacy and security probably will merge both in the kind of practitioner side, but also probably on the software kind of vendor side. I'm wondering, with these new requirements, are you trying to piggyback on existing patterns or plays that are run by the security? And if you are you seeing amongst your peers kind of gaps in those areas, or just how do you fit these 2 things together? Because at least as a market watcher and just someone participating in the community, there's a lot of stuff that security vendors who facilitate, pure play security-driven pen testing assessments, et cetera, those requirements are filled in large part. There's maybe a few exceptions in very privacy-centric nuances, but are you thinking about kind of piggybacking, or are you thinking about there's a huge gap? Like, I'm fascinated to see where the market decides they're gonna go from a tooling perspective in this.
Yeah, so I think it's still too early to know exactly. I think the first question you need to ask your CISO, your new friend, is what are we already doing? Because you don't have to reinvent the wheel. And the law is very clear in that to the extent that you're already doing something that meets the requirements of the statute, you can repurpose it. So you have to conduct a gap analysis of what are you already doing versus what do you need to do? Is there even a gap? Probably, again, it depends on your company, but your company is looking at a lot more in terms of the assets and in terms of the databases that they need to secure than what you may be interested in. But there also may be things that are very important from a CCPA perspective that the security team doesn't think is necessarily as important as some mission critical asset. And those are the pathways that companies need to start navigating soon, I would say, because especially if you're going to be auditing yourself over the calendar year of 2027, nobody wants unwelcome surprises in 2027, and we have some runway now. And I know it's hard. It's hard for anyone. It's hard for me with age assurance laws and settlements coming. You got to read all the time, and new states passing amendments. It's a very rapidly changing landscape, and it always has been, and it continues to be. But this is something I think that companies will ignore at their peril.
Mm-hmm. I think we hear generally related to the cybersecurity assessment, get a data map in place.
Yeah.
Max, I'm curious from your perspective as a builder, has this new amendment made you rethink the way you're thinking about the data map product or expansion of it? Because I imagine as a builder of privacy software, you maybe never thought folks would be coming to you saying, how can you help me with my cybersecurity assessment? But now maybe they are. Does it change the way you think about the evolution of the data map?
Yes and no. I think yes, from the perspective of these requirements are quite a bit more robust than we previously contemplated. We've always felt that there's a convergence and an overlap, as you mentioned, between privacy and security. The practices in place for how you secure information and the processes that surround access controls and things like that, those manifest in these requirements. We've always contemplated those. But the rigor that's going to need to exist around auditing those particular things, it starts to bleed into a totally different software category. And I actually don't know how those things are fully going to fit. I think if we were going to go and do every single thing as listed, there's stuff that hasn't been contemplated probably for any privacy vendor. And that's where this privacy, security, software category, partnership overlap problem gets a little bit more interesting. And so I think I've always felt that the security space will join the privacy space. We've already seen that with Security AI and Beam, maybe for different reasons, but I expect that there's going to be a lot more partnerships to fill this need, and or the burden is going to fall on folks like you to kind of stitch it together.
That's nothing new. That's who that's why we got it. That's why I got it, and I feel like that's why most of us did.
So yeah, I'm excited about that actually. I mean, just like you can be a builder, but you can also just kind of watch the market unfold. And I do think that this is just another catalyzing event that will make pure play security companies think, oh, this privacy thing we've been talking about, it's interesting. We need to figure that out. It's only going to bring those two categories closer. And of course, there are going to be vendors that make claim to supporting all of the things all under the sun. And I think privacy pros over the last 7-8 years have realized the one shop for every single thing humanly possible has downsides, notably in depth and expertise in each of the discrete categories. And that's why you see cookie banners that are in a broad shop or portfolio of products are woefully insufficient. I don't know the answer, but I do think that it's going to cause more convergence in the spaces.
Mm-hmm. Well, as you said, Ezra, moving fast, time will tell. Who knows? We all signed up for an exciting journey here.
That's right.
Well, gentlemen, it's been a pleasure talking with you both today. Really appreciate you coming on the Privacy Huddle. Max, as always, thank you. And Ezra, thanks for joining us for the first time.
Thanks for having me.
Thank you.